Maneva na sema PENDREAM TV. PENDREAM TV de osia dem yopo.
Memo bibiara kwaba eba PENDREAM TV. So you new to the channel, subscribe to the channel, bell notification no. Na share ma afofro ensa enkemi comment section ho. Nowadays wadrenche aba. Anda Nana Adodankwa Akufuado, the OSP, and as a special prosecutor Kisi Ejaben. Eka se ono oye ankwa noma na oye de obetimi nimre so a na oko. Eneno it is the OSP versus Dr. Dominic Anyene ene afensu no the High Court. Na eneno Deputy Attorney General Justice Srimsai the fresh details on allegation Attorney General EPSA will take it over the OSP. Yeah, who details no this video yeah me babebo actually the Jibre Nati the details from Justice Srimsai.
That's the Deputy Attorney General, Dr. Justice Srimsai, has debunked assertions that the Office of the Attorney General wants to take over the cases of the Special Prosecutor's Office. Well, amongst other things, he indicates that the OSP ought to seek authorization to prosecute, as has been the case for other security agencies. He's also dispelled allegations of turf war between the AG's office and the Special Prosecutor's Office. Now, the matter of authorization, he says that the Special Prosecutor has effectively refused to come to the Attorney General for authorization for cases, instead of the Attorney General rather being called to then issue a fiat in this instance. He says that per the law, it is the Special Prosecutors that has to come to the Attorney General for authorization. Let's take a listen to him, and we'll get into other matters as this issues plays out, and we'll be joined by a private legal practitioner as well. Take a look.
There's been instances where the agencies, other state agencies, law enforcement agencies that we give fiat to prosecute cases have been questioned. I remember one was on SEPS, Custom Excise and Preventive Service.
Giving them a fiat to be able to prosecute.
Yes, so that was, they used to be called SEPS, now they are part of GRA. At the time they were SEPS, they had a fiat to prosecute. But when the legislative review came and they became part of GRA, GRA is now a new legal entity. They were prosecuting someone who said that they didn't have a fiat. They were trying to say that they had a fiat when they were SEPS or something. But now they don't have it. The courts decided in that case that since you don't have the fiat, you couldn't, Recently there was a couple of cases like that. So this is just a normal thing that happens if you are, of course, if you are being prosecuted and you have any doubt as to who the authority of the person prosecuting you, I think you are entitled to, as it were, challenge it. And that's what the person did. We were not aware of this case. That's the Office of the Attorney General. Personally, I don't even know this accused person. This file has never come to our office. We, just like everyone else, got to know of the decision that the court has ordered that we should go and take over the cases on grounds that the OSP was not able to show that they have authorization from the Attorney General, contrary to their own act. So the case that happened in the High Court had nothing to do with constitutional interpretation, because the act, I don't know if you have looked at the act, but the act specifically says that
the objects right in front of
you. Subject to Article 88, the OSP will prosecute based on the authorization of the Attorney General. That's what the legislation says. So the person is saying that if you are prosecuting me, then you should show your authority note upon which you are prosecuting. That the OSP was not able to show. So the court,
right, to the extent that a similar matter is currently before the Supreme Court, and in a criminal jurisdiction of the High Court, that judge had stayed their hand, deferring on to the Supreme Court to make a decision. Many will say general jurisdiction could have stayed its hand as well. Yes, that doesn't fall within your remit, but
yeah,
in terms of what played out.
In terms of what, I don't have the full record, but what I know is that the mere pendency of a similar matter in the Supreme Court does not operate as a stay to any court that is deciding. It is good if the court is aware, or it has been brought to the court's attention, and the judge decides that, well, I will wait, that is fine. Even if a judge knows and decides that I won't wait, I'll make my decision, it doesn't invalidate the decision itself. Yet you may question the judge's discretion as to whether to wait or not, especially when I have no evidence that it was brought to the judge's attention and was he was prayed to stay. But be that as it may, like I said, we were not parties to the case, so we didn't know what happened. The decision has been made, and we have been asked to order to do certain things. So we just have to do it. Why would someone interpret this as we are in a hurry to take over the cases of the special prosecutor?
In reading the orders of the High Court, which has now become the subject of the conversation, yes, he ordered that the AG takes over the cases pending authorization to the Office of the Special Prosecutor.
Precisely.
Many will say that should be of concern to the Attorney General, given that authorization for that matter to proceed.
It is
instead of.
It is of concern to us.
The decision to want to openly come out and state that, okay, we're taking over, and no mention at all as to authorization.
No. What I put out yesterday did not say that we are taking over cases.
In the coming days. I
said we'll take steps to give effect to the decision of the court, right? So, like you said, we should be concerned because as far as we know, all prosecutions in the country is being done in our name. So if we are there and the court says that there is this number of cases because the OSP doesn't have power to prosecute and is prosecuting, we should take over. Do you want us to spend 1 month thinking about what to do, or you'll be interested? Like you said, we should be concerned. And my understanding of concern means that we should do something to remedy the situation. That is what we are going to do. So why would someone interpret that to mean we are in a hurry to take over the cases? So the point I'm trying to make is that I appreciate I won't call it propaganda, the misinformation out there. Because yesterday I was speaking with someone who said, it was actually a radio, presentation. Somebody said the AG went to court to ask that the OSP be sacked, which, first of all, we didn't go to court. We were not even aware of this case. So
we'll come to the aspect of conversation surrounding whether or not this is a grand scheme of some sort, particularly in relation to the matter before the Supreme Court. But on the subject matter of authorization, where have we been in the past in terms of the work that has been done by the special prosecutor up until now? Because there's an argument that's been made that the former Attorney General, Gloria Kufu, took the bill for the creation of the office to Parliament. By that singular act, it became a delegation of some sort of the prosecutorial powers.
Okay, that clearly is a misunderstanding of how the lawmaking process works and how law actually works. It's a total misunderstanding of it. When you send a bill to Parliament, okay, you are not the owner of the law that comes out. You are neither the author of the law that comes out. You are not the lawmaker. So a private person who takes a bill, there are two pathways to sending a bill to Parliament. One that will be sent by a private member and one that will be sent by the government. Whichever way the bill got to Parliament, once Parliament does the first reading, it is entirely Parliament's creature. Parliament is the one responsible for the bill. So Parliament that's because Parliament can change the bill, anything in the bill, including the memorandum, can change anything and pass a bill that you may not even be interested in anymore, but they will pass the bill. And that is why there is another provision that when the bill is passed, the president should give his assent, because it is a recognition of the understanding that you taking the bill to Parliament does not mean that you are the one, you have the final say. So if Parliament has finished with this process, then the president will give his assent. The giving of the assent itself is not an authorization. It's not the fact, it doesn't mean that the president is making the bill, or he's just saying that this bill, I agree that it has been made. Thirdly, it doesn't matter how all this went. Otherwise, if that's the case, then we can never declare any law unconstitutional. The fact that it has gone through legislative process and has come out as law doesn't mean that it is sacrosanct. If it were, then there shouldn't be any provision in Article 2 which says that when a law is made contrary to them, you can strike it out. So the argument that because the AG participated in the lawmaking process, it is neither here nor there as far as law is concerned. Maybe for other areas of thought and discipline, maybe that matters. But as far as law is concerned, and my understanding of law doesn't tell me that when you participate in the lawmaking process, whatever comes out, then you are deemed to be the maker of the law. The law can come out, in fact, you can even comply with the law, and what you have done in accordance with the law will be nullified. Right. So it is not one of the arguments that carries weight as far as this conversation is concerned. It has no merit as far as the issue is concerned.
So since the assent to that OSP Act in 2018, there has not been any executive instrument from the Attorney General's office giving authorization. As
far as I know, there's no executive instrument to authorize the Office of the Special Prosecutor. And indeed, I think the case we just discussed gave the opportunity to the OSP because they were parties to the case. So if they had such instrument, they would have presented it. And if they had any argument to make, whether legal, like even including the one you just put to me, that the participation of the Attorney General in the whole process should be deemed to have been authorization. If they had any such argument, definitely they would have put it before the court. And if they put it before the court and the court weighs it and decides that that is not it, it is not for me to decide. That is why we are saying that the court has heard a matter, he has made orders, we're not parties, but the orders were directed, at us that we should do something. We cannot disobey the court, neither can we ignore the court and sit down unconcerned. It's a serious matter because we are talking of corruption, we are talking of justice, we are talking of human rights here. We can't sit down and say, that would be irresponsible for us to sit down and think that because we're not parties to the case or because of some other consideration, we will not take any steps. So we will definitely take steps to remedy the situation.
In taking the steps, and we're talking authorization, because it doesn't look like it's powers to investigate and all of that has come up.
No, it's just the prosecutorial.
It's just a prosecutorial.
Yeah.
Why haven't you granted that in the wake of all of this? There are those who say you're waiting on the office to write to you before you issue that.
Yeah. There is a process for issuing the EI. You can't sidestep the process and see. And in any case, okay, let's grant it. Let's assume that there's even no process. What is wrong if the OSP writes to seek authorization? Is that not, if you want to drive, do you sit at home for DVLA to come and look for you and give you a driver's license? Don't you take steps? If you want electricity in your house, the fact that you want electricity, ECG needs your money. They know you need electricity, but don't you take steps to apply for the connection to be done? So, and is it so difficult to apply? If it's not difficult, why is the application not being made? Why is the question always to the AG that we should rather, so we should go, and when you apply for EI, you have to show that you are giving the EI to this person, because the law, the person who is doing the prosecution, not the office. Office is not the one, it's the human being who is a lawyer who is doing the prosecution. So that is how is there any reason why you think that the application should not be made? And why do you think they are not making the application?
That feeds into perceptions that there are simmering tensions between the OSP and the Attorney General's office.
As far as I know, there is no tension between us. I mean, we've been collaborating, and a lot for that matter. So, and the collaboration, it's not everything that we can put out. I hope you understand, because we are law enforcement agencies. There are so many things that we can discuss, but we can't put out. But I am not aware of any tension. Neither am I aware of any fight between the OSP. Other agencies are always. Recently, Gold Board applied for executive instrument to prosecute. NACOC So they are all applying. I don't know, unless there is a reason why the OSP will not apply. But if OSP applies and we say we will not grant, I think then you can say that you can question us, why are you not granting?
Well, so that's Dr. Justice Adam Sremsai there with that conversation with my colleague Eric Marwana Egbeta on this. That point that he ended on, that the Marwana asked a question about this seeming tensions and tough war between the Attorney General's office and the Special Prosecutor's office. He says they've been collaborating, they are working, and there's no tough war. And private legal practitioner Henry Mamhes is going to be joining us in a bit. That particular issue that he answered to is what the former special prosecutor, or the first special prosecutor of the Republic of Ghana, Martin Alamisi Burns Kaiser Amidu, has also been writing about this. He says the relationship between the special prosecutor and the Attorney General under this government has broken down beyond repair. But Dr. Sremsai says they have a good relationship. They've been collaborating and working, okay? And then again, whose report are you going to believe? It's a matter that obviously has to be gotten into. The Attorney General's statement of case does not appear to objectively, neutrally, and impartially present an ethical response to the plaintiff's case. And in this matter, they're talking about, he's referring to Noah Adamte, that's Tete's case. He says that the Attorney General's statement of case does not appear objectively, neutrally, and impartially, and in fact present an ethical response to the plaintiff's case. There was no tough war between the Special Prosecutor and the Attorney General during my tenure to warrant a challenge about the constitutionality of the said office, the Special Prosecutor. Martin Amidu continues that the Attorney General's statement of case does not even hide his partisan interest in the plaintiff's case when he fails to show which portion of the plaintiff's case the court should dismiss. This is just portions of Martin Alamisi Burns Kaiser Amidu, the former special prosecutor's position on what has been playing out between the Attorney General and the Special Prosecutor's Office. On the matter of authorization, here Justice Adam Sremsai says the Special Prosecutor does not want to come for authorization. We understand the Special Prosecutor's position is the office is independent, so why do they have to come for authorization? But then you hear the Attorney General, the Deputy Attorney General, reference Article 88 of the 1992 Constitution. So at the heart of all of this is whether or not the Special Prosecutor needs authorization to prosecute cases that it is pursuing. Lawyer Henry Mamhes, good evening to you. Thank you so much for joining us here on Ghana Tonight.
Good evening and thanks for having me. It's Christian.
Are you able to put the video on for us?
Yes.
I think
it's on.
No, unfortunately, it's not. Oh, okay.
It's on. It's coming from your side.
Okay. I think you just have to put it on for us while we run through. But I'm just going to kindly stay with me while I run through Article 88 of the 1992 Constitution, specifically on the matter of the Attorney General, the reference that he makes. That one, there shall be an Attorney General of Ghana who shall be a Minister of State and the principal legal advisor to the government. Two, the Attorney General shall discharge such other duties of a legal nature as may be referred or assigned to him by the President, or imposed on him by this Constitution or any other law. Three, the Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offenses. And this is where the emphasis is on, Article 88(4). All offenses prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by the Attorney General in accordance with any law. This is where the issues really are and why all of this is playing out the way it is as we speak. And also why the Deputy Attorney General, you hear him raise issues regarding the position that the Special Prosecutor has taken on this particular issue of whether it needs authorization or not. Let's go to Christian Mamahese right now. He is private legal practitioner. Counsel, good evening. Can you hear us clearly now?
Good evening, and thanks for having me.
And first of all, I want to find out from you your thoughts on this, how this matter has been playing out, and listening to the Deputy Attorney General specific on the matter of authorization. He says, well, the law is clear in Article 88.4. That is what they are only going by the orders of the High Court to execute what the High Court has told them to do. And if the Special Prosecutor needs authorization as enshrined in the law, he must come. It will only be an issue if he is denied authorization on any case that he is prosecuting. Then we can talk about a turf war. Until then, he says there is none. Your thoughts on this?
Yes, good evening to you and your viewers. Indeed, I mean, we are governed by rules and regulations. And in legal theory and jurisprudence, for a legal society or for a legal system to exist, it is hedged on secondary rules. And secondary rules are meant to ensure that there is certainty in law, which cures the primary rule, where in the primary rule there is no uncertainty. Indeed, the OSP Act was promulgated in order to cure a certain mischief which existed in the primary rule. Now, the OSP Act, as it's presented, has section, aside the objects of it, and then looking at section 1, section 3, and section 4.2. Section 4.2 deals with the fact that the OSP has to seek the authorization of the Attorney General when it comes to its prosecutorial powers. Now, when you look at the objects of it too, it indicates that the OSP is vested with both investigative and then prosecutorial powers. Now, the first one is very, very, very solidified. The second one makes the OSP subjudicated to, or its function of prosecutorial powers is subject to that of the Attorney General. So, in the quest for the OSP, whenever it seeks to prosecute any of its corruption and corruption-related cases in court, then it needs that authorization or executive instrument from the Attorney General's office in order to do so. And where it seeks to carry out that, then we would say that there has been a statutory breach. And to that extent, that statutory breach ought to be cured in order for the OSP to have recourse to that particular function. Because by the wording, by the text and context, or the statutory interpretation of it, subject to Section 10 of the Interpretation Act, the OSP is enjoined to seek that clearance or such leave or such authorization from the Attorney General in order to carry out that function. It does not mean to say that the OSP's prosecutorial powers has been taken away from it. No, because we have other state prosecutorial agencies that seek same leave, or when we say leave is permission, that seek such leave from the Attorney General to carry out such procedural functions. And for the fact that the Act that gave birth to the OSP never gave the OSP that autonomy in terms of prosecutorial powers, then whatever is vested or whatever is crafted in that particular Act is the function that OSP must carry itself in. So OSP cannot carry itself out of that particular function, but the grand norm, that is the law that, or the rule that it traces its powers to, is that which it must rail itself and function accordingly in order to attain the end of whatever it seeks to do. So in all of it, it is more of a collaborative function between the office of the OSP and that of the Office of the Attorney General.
Do you get the sense that
do
you get the sense that that collaboration still exists, or, as it were, Martin Amidu says there's clear indication that collaboration has broken down, and that's why it's playing out the way we are seeing it right now?
I mean, obviously, to the general public, the cracks are showing, and indeed, the only way that this could be rectified is where the Constitution is amended in terms of the powers of the Attorney General, and it is for the framers to decide whether this subjudicated authority would exist between the Attorney General's office, or yes, the Attorney General's office and the OSP, or it would decouple the OSP to run a parallel prosecutorial powers with the Attorney General. Because if you look at the statute, it is what it is. And indeed, if you further verse to what the court did at GJ10, the court has every right in order to deal with constitutional matters. I mean, I am at odds with a number of lawyers who have been on other platforms to say that the High Court had no jurisdiction in dealing with constitutional matters. And I shudder to say that.
No, not necessarily constitutional matter. There was the question was about the interpretation, the powers of interpretation, which is the exclusive jurisdiction of the Supreme Court, is it not? I mean, I think that's quite clear and it's elementary. Now, that was where the High Court's powers were called into question on the matter of whether or not they had the power to interpret the specific provision of Article 88 as and how it impacts on the law that establishes the office of the special prosecutor. That was where the matter of the Supreme Court having the powers, the exclusive jurisdiction to interpret.
If I would hollow a bit on it, I would say that yes, under Article 2.1 and Article 130, individuals can bring matters to the Supreme Court for constitutional interpretation. And in dealing with the Supreme Court's powers are vested in exclusive original jurisdiction, enforcement powers, final appellate jurisdiction, and then supervisory jurisdiction, including habeas corpus and mandamus. Now, if you come to the High Court also exercises general jurisdiction in criminal and civil matters. It also has jurisdiction in fundamental human rights,
yes,
referral matters under Article 132, and also when it comes to interpretation, it has a limit to what it can do. Now, this limit was hallowed in the case of the Republic versus Mike Kankan and others in 1971, 1973, where it indicated that when it has to do with ambiguity, then the High Court ought to refer the matter to the Supreme Court, because if it does not do that, then it is extending its powers into unwelcome territories, and that would cause that decision to be quashed. Now, it was further enforced in the case of ex-party Dr. Zenator Ajiman Rawlings, where the Supreme Court had the opportunity to say that when it comes to constitutional interpretation, the High Court can only engage in what we call the application, so that we have just made it in the simple terms that the litmus test is, will the High Court exercise applicatory jurisdiction to constitutional provisions? If it seeks to do that, then we say that the High Court's powers is intact, or its jurisdiction has properly been invoked, albeit so that the High Court will deal with the normal constitutional matters that comes before it. But then if it has to do with enforcement, then that would mean that the High Court would have to stay proceeding. That was what was his name.
Okay, so I get the point. I think you've established the issues to the perspective of how far the High Court can go in the matters of interpretation. This is a matter that is rolling out in many ways. So we're going to stay the steam on it, and, as we await how things will play out in the coming days. Christian Mamhesi, thank you very much for joining us here on Ghana Tonight. You'll recall that when this matter came up, there was some conversation as to whether this particular outcome of the High Court's decision can extend beyond the particular case in question regarding the rice scandal to other cases that the special prosecutor is pursuing or prosecuting. Well, from what we understand now, the outcome covers all cases that the special prosecutor is prosecuting. But we'll get a bit more detail into this because Dr. Adam Sremsai, earlier today, my colleague Eric Mayonegbeta sat with him exclusively, the Deputy Attorney General, to get a bit more detail into what has been happening so far. But here's what we do know when it comes to the special prosecutor's performance over the period. About 100+ cases currently under active investigation. This is what we got from the special prosecutor's own half-year report that it has been putting out or publishing as the law demands. And we'll put that on the screen right now. There are 33 persons that are currently facing trial, and there are 78 criminal charges that have been filed, for instance, in the Kenofriata and others case. Now, what this essentially means, if what we understand is anything to go by, all of these 100+ cases currently under investigation and the active investigation would be, that is, if the Deputy Attorney General's indication that he gave is that in the coming days, the Attorney General would begin processes to take over all the cases being prosecuted by the special prosecutor. Then what you're seeing here now would be under the umbrella or the remit of the Attorney General. But this also brings up other questions which we're going to be getting some answers to. When it comes to the number of persons who are standing trial, 33 of them. Now, there are civil proceedings, about 10 counts, and then also there are ongoing investigations, 79 counts as we speak, and just about 7 convictions secured so far. And there's persons who criticize the office by pointing to the 9 years that the office has been in existence, and just about 7 convictions have been secured so far. But the Office of Special Prosecutor has always been consistent in mounting the defense as to the other things that they are doing as well in the office to ensure that the office is achieving its set objectives.
PENDREAM TV now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.